Welcome to the Estates Made Simple podcast. We started this podcast to provide good information and simplify the world of estate administration. And my co-host in trying to achieve that objective is Jenna Carvello of Guardian Estate Company. I'm Gordon Vanderleek of Vanderleek Law. Welcome to another podcast, Jenna. Yeah, it just seemed like it was just recently that we were doing this, and we get to do it again. It's always a highlight on my calendar to talk about estate administration issues and have this conversation that we can record for our listeners.
Yes, I think, it's always fun to talk about these issues. I hope our listeners find it as fun, as exciting as we do, right?
Exactly. Listening into our coffee conversations about these issues. And of course, they're conversations meant to provide some information and be useful to you, maybe spur some thoughts that may require a deeper dialogue or retaining professional advice to give some information regarding your situation. So certainly the caveat here is, of course, not knowing individual listener situation, we can't give legal advice, nor should this be constituted as legal advice, but we hope it's helpful. And if you have any questions, please reach out to us. Jenna, today we're talking about beneficiary designations. It's, I think, one of those things that can have a huge impact if done poorly, and maybe people don't think about too much, or it's easy to forget. So maybe with that, we thought it was worthy to spend a few minutes to talk about it. So maybe introduce the topic a little bit for us today.
Yeah, well, thanks, Gordon. So as we have read about previously, there are estate assets that can come into the estate and pass to beneficiaries in accordance to the will. There are also assets that can pass outside of an estate and be governed by the policy itself or by the documents that establish those assets. So some examples might include real property with jointly held names that would pass outside the estate to the joint owner. Another example is life insurance. You can actually name a beneficiary right on the policy itself, so it passes outside the estate. And another example, which we're going to dive into today, is registered products. And so it could be RSPs, TFSAs, RIFs, anything with a registered status. You can name a beneficiary right on the policy itself. So the issue arises when you have different instructions on the policy as well as in the will. So some individuals name beneficiaries right in the will with regards to these registered products, and other individuals name it right on the registered product itself. So there could be conflicting instructions. We wanted to talk about that, highlight that as an issue that an executor might face, and talk about some best practices when you are reviewing the beneficiary designations and administering who those assets go to.
Yeah, and it's really important to note one of the implications is who's going to control the proceeds of those, either an insurance policy or that savings account which is registered, like a RSP or a RIF, and the tax-free savings account. And what's interesting is I think the trend is that certainly the TFSAs have been around since 2008, and we see them accumulating to some larger numbers, right? It's not uncommon to see them into the 6 digits or the high 5 digits, right? That people have saved a lot of money, and if they've been doing that over time, then it can accumulate to a significant amount of money. So it deserves some planning, it deserves some attention. Even with the RSPs, that's people's pensions, if you will. That's their long-term savings that they've been spending their adult working life building. So it could be a sizable amount of money, and if done poorly, can create some friction or potential litigation in the estate. And I find when I'm talking to people on the estate planning side, while we're speaking of the role of an executor or an administrator in this context, in the context of this podcast, a lot of people go, well, I don't remember. I think this is who's designated, but I don't know. Right. And so it's part of what can flow outside of the estate. If you're the executor, you could argue, you don't have to worry about it because it's going to go to the designated beneficiary, so it's not part of your task. But one of the tasks would be to actually make a determination. So the first thing for an executor would be, well, is it part of the estate, and therefore does the executor have to control it? And if if you find out there's a beneficiary designation, well, then it's up to the person named to deal with that financial institution or the insurance company to process that. All of that to say, I guess to summarize, it would be who's controlling this wealth, like what's in the RSP or what's in the tax-free savings account, or that the proceeds on death from the insurance policy. Again, insurance policies can be a large amount of money. You could have $500,000, $1 million, $2 million, right? Even the smallest ones tend to be like maybe 25 or 50,000, some basic coverage. That's a lot of money. And we want to make sure that we identify where some of the pitfalls are and the planning opportunities for that. But really what it comes down to is who's controlling it. Like, does the executor control it or not? And the takeaway for our listeners will be, if there's a designated beneficiary other than the estate, then the executor does not control it, or the administrator, right? It's outside of their control. It's outside of the estate. It passes directly pursuant to that contract, because the person has said, well, when I die, this is where the money goes. And it doesn't matter. Now we get into then, well, what does the will say? So the other thing to be aware of as a general rule is it's last in time wins, or governs, if you will. I guess wins in the context is there a fight about where does this money go? But as you point out, if the will says, let's say it's mom's estate we're looking at, and there's 3 children. Well, what if the insurance policy says 1 kid? Well, that insurance policy proceeds go to that 1 child, even though the will says 3 children, divide equally between my children. Well, now we have a different result, which brings up the question, did mom intend that or did mom not? So it is important to identify right now. And if you're listening to this and go, yeah, I wonder who, if you're asking the question, I wonder who I designated on my insurance policy, my RSP or RIF or the tax-free savings account, then go and figure it out, because the last one in time governs. So technically you can actually change the designation in your will, but it's not a great place to do it, right? Because now the institution that's holding either the insurance company or the financial institution, they have to have a copy of the will. Well, you've lost some privacy with regard to that. Now they get to see your whole will, and do they accept it? Do they not? And do they get it in time? So the better thing always is to go directly to the company, who, the insurance company or the financial institution or your financial advisor, your broker, and say, give me the beneficiary designation form. Let me set it up the way you want. And then that's where, with advice, you can make sure it's going to the right people in the right proportions and under the right circumstances, right? Sometimes it's easiest just to say, make all your beneficiary designations payable to the estate, and then all you have to do is read the will, and the will govern the distribution, whatever the instructions are in the will. But it could very well be, and this is kind of what you highlighted, is there could very well be a situation where the beneficiary designation is different. It's great if that's by design, but oftentimes people are left with that feeling of, I wonder if this is what mom wanted, and maybe create some friction in the family. In my example, the other 2 children are going, well, you're going to share that, aren't you? That was, mom wanted to divide everything equally. Oh, no, mom liked me better than you. I get to keep that money, right? Because I'm, legally, it would be true. It goes to the 1 kid. So right there, now we've created some friction, which could have been easily solved had mom just put some thought to it, completed the proper beneficiary designations, and then communicated her wishes to the kids. That it's not a problem. Go, I want to leave 1 to this child for this reason. So you could have some problems there. But yeah, last one, point number 1 would be the executor doesn't control anything falling outside of the estate by way of a beneficiary designation. An exception to that would be if it says the estate. And then number 2, the last one in time would govern, whether it's in the will or the beneficiary designation. But best practices would be get it the way you want it and make sure it's current, so there's no surprises.
Well, and I think some of these issues can arise when people try to avoid probate. And as we chatted about previously, probate in Alberta is not that expensive. It's very nominal fee, around $500 for any size of estate, really. So when you're making named beneficiary designations, consider, like what you said, Gordon, consider paying it to your estate if you want your estate divided equally, or dealt with in accordance with your will, rather than giving it directly to that 1 child and having them have the moral obligation to divide it between the other kids. And I'm curious too, if you think there's any liability from a bank's perspective, because often, insurance policies as well as registered products get paid out quite quickly following the death of an individual to the named beneficiary, if there is one on file. What if the bank doesn't review the will? Is there liability on their hands because the will could say something different with respect to those individual policies or products?
So yeah, point number 1 is there's a specific way you could do that within a will and have it a declaration under the Insurance Act or effective for the RSP or the tax-free savings account for the registered accounts. But there's always that risk of, well, what if they don't accept that as a proper declaration, right?
Right.
And they did it informally. Maybe it was a do-it-yourself thing and they didn't have the right language in there. And yeah, what happens if now you send it to the insurance company company, but what if they lose it or they say we never got it? Now we've set up a fight about what happens to those insurance proceeds. Over the years, I've been involved in some contentious matters where we had to move very quickly to stop the payout from occurring. But I've seen instances where somebody shows up and says, I'm the beneficiary designation. Within several days, they have the check, and then it's too late. Now you're chasing that person for that money. That becomes very, very difficult. So yeah, while it's possible to do in the will, you want to make sure you do it directly with the institution and have them acknowledge receipt of it. So I don't know, I would feel a little bit nervous if you just like especially for a big company, like an insurance company or a bank, like who's the right person? Where do you send it to? What if you send it to somebody thinking it's going to be effective, but they forget to pass it on to the right person and it doesn't get in their computer system, right? There could be all sorts of problems with that. So it'd be best to say, use their forms, use their beneficiary designation, and get some advice on how to structure it. I've certainly seen situations where people, if they have a disabled child and they want to leave money, maybe some extra money for that disabled child, right? An extra insurance policy. Well, they'll name the kid on the insurance policy, but I've spent a whole lot of time crafting a very careful trust for the lifetime of that child, sometimes referred to as a Henson trust, expecting the money is going to go into that trust and be managed by the person appointed pursuant to the trust. But it turns out that the money's going directly to the kid. Well, that may disentitle them from government supports. Again, just one example where there could be a problem. So really it points to saying you need to put some forethought into that, figure out where, I think do what I might refer to as a flow analysis, that figure out where is stuff going to flow when you pass away, and then is that what you want? And then if not, we can make some changes very simply by changing the beneficiary designation to align with the objectives of the estate plan. At the end of the day, we can all control what happens to our insurance, our RSPs, and our RIFs. And we want to make sure the beneficiary designations are set up properly because it involves a good chunk of what you regard as your estate. You go, well, yeah, this is stuff that's going to my family, or as you would want. You want to make sure there's not inconsistencies on that for sure.
Well, and I think those are great tips from a planning perspective. And for our listeners who are already acting as an executor, make sure you review, as Gordon mentioned, if you are in control of the product or of the insurance policy payment or of the registered accounts. If you are in control, review the investments to make sure they're still prudent before payment to the estate. And if there are conflicting instructions, so maybe the policy says that, or the RIF says that the payment should be made to a child and the will says that the payment should be made to a spouse, consider seeking legal advice, getting some expert opinions before proceeding one way or the other.
Yeah,
and really consider the tax implications for those registered products after death, because some of the income could be payable to the estate after death, income earned on those registered products. Typically, TFSAs, of course, aren't taxed until death, but any income earned after death on that TFSA account could be taxed by the estate. So it's important just to consider those types of tax implications on those products.
That can be significant. I've been involved in some cases over the years where had it gone into the estate, there would have been a rollover to a spouse or to a designated person. But because it went outside the estate in the context of an RSP or RIF, it's another point for the listeners, is the tax liability for that rests with the estate, not with the person receiving it. So now it becomes a question of, is the financial institution on the RSP going to deduct at source for the anticipated tax? There could be a big fight about who's going to pay the tax liability, right? And so just be aware, specifically with regard to RSPs, there can be, from a planning perspective, there can be some issues, and it's a very germane point on the administration of the estate and one that has to be investigated as to where is it payable, because ultimately the executor, when filing the tax return for the deceased, has to include all the income from the RSP and end up paying the tax. So that comes out of the residue of the estate, affecting the residual beneficiaries, and that may be person on the beneficiary designation for the RSP may be somebody different than the residual beneficiaries. So now we have this fight about who's going to pay the tax on the RSP. If it doesn't go over to a surviving spouse, if we're dealing with the death of the last of the two of them to go.
Well, and most of the time the banks do not deduct at source for the payment of the RSP. And that's a surprise for many clients. So great point. Consider the tax implications there.
Yeah. We had a case where somebody just leave it to my friend, and he wanted the residue of the estate ended up going to his family. Well, the family's share got ground down by I think it was about $140,000 of tax on the RSP, and the entire amount went to the friend.
Yeah.
And they said not fair, but that's the scenario, right? The only recourse on that, I'm just thinking of one little tidbit, would be if there's no money in the estate to pay the tax, CRA can chase the RSP proceeds to the beneficiary and make the beneficiary pay, but otherwise the beneficiary is not liable for that. There are some cases in this area that discuss this further and go both ways on it. But at the end of the day, I think your point is when you're thinking about where assets flow on death and you're looking at registered investments, which could have a tax implication, you definitely need to think about that ahead of time and get some prior advice to make sure we don't end up with a weird result that is not intended.
Right. Well, I think that's some good points for our listeners today, and always a pleasure to speak with you, Gordon. For our listeners, please feel free to subscribe on YouTube or wherever you listen to podcasts. We'd love to have any of your ideas for future topics. We're always open to discussion, and we love this stuff. So feel free to reach out and have a chat. Thanks, Gordon. We'll talk to you soon.
It was a pleasure. We look forward to the next time we get to chat.